Hello, Facebook, all of our watchers, our members, our real estate investors. I have a very special guest, and tonight we're going to talk about the landlord and tenant board and forms. You know, we're very much involved in doing these Facebook Lives that talk about landlord issues, talking about the landlord solutions, trying to get heard as landlords and investors and paralegals and property managers. And it goes slow. It goes really slow, but we have to continue to keep advocating. And while we keep advocating, we have to know about the rules and the procedures and the stupid book that we have to follow now. And sometimes it can be really complicated. And that's why I have Leanne Thibert. I was practicing how I'm like, Thibert is it? She's like a Thibert. So I have Leanne, and she is the owner of Act Legal here with us tonight so that we can try to get your questions answered if they do see them pop up on the screen, if you're with the StreamYard approach here. If not, I definitely have a lot of questions that I hear from the Ontario Landlords Watch members, and I want to try and bring that to Leanne tonight to get her opinion and a way for us to try to walk away from these common mistakes that most of landlords are making and tips on how to win your case. So Leanne, thank you so much for coming in tonight and sitting here with me and talking about this crazy world that we live in Ontario when we have to deal with the landlord and tenant board. And before we get started about the chaos, tell us about you. How did you get in? Why did you get into being a paralegal for law and the landlord and tenant board?
I have always had a passion for advocating for others, and I've always had an interest in justice. When I was 16, I held my first ever protest, and I really felt like, I had something to bring. I had a voice, and I wanted to be heard. So I eventually got myself together, went to school, and became a paralegal. I graduated first in a class of 120.
Wow.
And yeah, it's been a lot of fun ever since. So
now
that is my story.
I have to ask everybody now, what is the biggest concern that you have with the Residential Intensive Act?
I'm sworn by oath to not speak ill of the justice system, and I have a great deal of respect for everything that our adjudicators and members are going through. Right now, I think the delays that we're experiencing at the board are my biggest concern. I represent primarily landlords, and for them, they're just not getting the resolutions that they need in the time that they need them, and they're not getting the orders out in the time that they need those. And in my opinion, having something written into the act to, rush those times or to at least protect the timelines that we should be seeing, that could be the biggest failing.
No, I agree. Now, if you had to change one thing from the RTA or the LTB, what would you want us to change?
Okay, that's a big question.
Can we call a friend? I don't have any multiple choice 50-50 on this show.
I think the lack of consistency is my biggest concern. I think that's what I would change. Not having one answer to a question and having everything be a gray zone is very concerning. And that's one of the biggest concerns that I face as a paralegal and as a representative. How do you advise your clients when the answer is always, it could go any way? So that I find is it's definitely the biggest issue that I have there.
Perfect. Now I'm seeing a lot of phone calls, a lot of messages, and even talking to our paralegal friends in the community about what is the most common form that landlords are having, that you're helping landlords deal with, based on all these lockdowns, the pandemic. What would be your form? Is it the N4?
The N12. I'm seeing so many N12s, and pre-COVID we did N12s, but I feel like everyone who calls is doing an N12. That's all we're doing now. And I mean, obviously, you still have the N4s, and those are piling up because people aren't paying their rent because they are out of work. But the N12 are the new big thing for me.
Big wave, and that's the thing, and that's what we've been explaining to our elected officials, that as landlords are fed up in the market and getting out of it and taking advantage of a hot market for their single family homes, townhouses, and whatnot, and condos.
They want out. Landlords want out. They're done. They're tired.
Go ahead.
It's just it's confusing, it's time consuming, it's costing them money, and then they're stuck in this situation where they're carrying mortgages on investment properties that they never expected to carry mortgages on. And you can do that for so long, but no one can do that forever, and not when it's multiple properties and it starts to pile up. And that's what we're seeing. We're just seeing landlords dumping properties left, right, and center. Nobody wants to be a landlord anymore.
And then is it going to be bought with the thought of being a rental? Probably not. And our elected officials need to know that they're losing more supply than gaining it. And everyone, all the elected officials said it's supply and demand, but they're not looking at what this wave of eviction bans have done. Now with the N12s, obviously you can give an N12 to your tenant saying, hey, I sold a place, it's a firm offer, but the tenant doesn't have to move out. They have to wait.
And they're not moving, Kayla. They're not moving. They know that they can wait for a hearing, and that's exactly what they're doing. Or they're coming to landlords with their hands out saying, give me $20,000 and we can negotiate. And it's across the board. You're seeing landlords with sales falling through on homes. Those are going to pile up in the small claims court now because we've got all of these breached purchase and sale agreements. It's not good for anyone.
And what would happen? Do you know what would happen from a breach of sale where you couldn't close because the tenant refused to go out? What would be the penalty for the seller? Oh no, I need to know this one. Hold on, guys. If I think I'm still alive and you can still see me, so we'll wait for Leanne to have her internet back. And I'll keep talking until that happens because we're live and that's what happens. So I'm really trying to get more information on this because it is a wave, and it is a wave of these properties leaving the market, and landlords are really done trying to be dictated by the government so bad that we need to encourage them, but we're not encouraging them anymore. And this is actually going to be really, they're going to feel this. And I almost call it like a mass exodus, but sometimes with a mass exodus, you would see it. But right now we have our concept where it's going to show, because some people do it with capital gains. They usually wait a little bit. Okay, so Dan said he can hear me. Thanks, Dan. I'm keeping an eye on the bottom screen right now for Leanne to show that she's coming back in. So she should be here any minute. So I don't rehearse this, so it's all live anyway, so I shouldn't be tripping up in my words here. But we do have this wave of N12s. I want to know, when we try to have an N12, you have a close hearing date that is coming, and we need to know how to avoid common mistakes on these N12s. And Leanne is back to tell us what common mistakes are made on these N12s.
Sorry about that. I don't know. It disappeared. So sorry, N12s. Across the board, there are some common mistakes that occur that it's not limited to just the N12s. Primarily, we see improper service. So documents are provided by posting on doors, or they're served by email. And that obviously can lead to a dismissal of the application. We have improper service dates, so timelines aren't counted correctly. You have people who are serving the N12, specifically the N12, are being served not to end of term or not to end of lease term, which is a huge issue. When people are purchasing, they're in a rush, they want the close date, the N12 is filled out on the close date or before the close date, and they're not taking into consideration the fact that there's an existing lease in place that spans a year or sometimes 5 years, and you have to take that into consideration, because if you're not doing it to the end of that date, that application is going to fail when you get to the board. And then the forms that are being signed by people like realtors or property managers, and they're coming into question saying, well, is this form even valid? It wasn't served by the landlord. It wasn't signed by the landlord. It wasn't signed by the property manager or by the legal representative. Those are issues that we're seeing now more and more at the board, with the members and just dismissing applications because the forms.
So the realtor signing or delivering the N12s, are we having a problem with the realtor delivering it or signing the N12?
Signing. We're having issues with the signing of the N12s, the signing of all notices. If they're not signed by the landlord or a legal representative, they're being called into question now. And a lot of paralegals out there are raising the alarm, and members are now on the watch. So it's definitely a big across the board issue with every form out there.
And which, if you have a property manager and they have that one-on-one connection with the tenant, like how come our property managers can't be signing these forms? Unfortunately, we have to get the landlord in order to sign them, in order to deliver them. And it'd be nice to have that shared. Now, for the certificate of service, any advice for common mistakes made on the certificate of service?
Really failing to list all of the tenants is probably the biggest one that we find.
That little bar that's in the middle.
That tiny little sneaky button that you have to click and then fill out your schedule of parties. That seems to be the biggest issue, though. Because it's not the actual notice, if you have someone there to testify to service, I find it's not as much of an issue, because at least that certificate of service is really almost like an affidavit. Like it's presented as evidence. It's not actually the notice itself. So as long as you have the person there to say, I did serve everyone, I must have just filled it out wrong, you can recover from that one, but obviously still not a mistake you want to make. You don't want to be in recovery when you're at the board. You want to just have everything go smoothly.
And what if a tenant disagree with having to move? Have you seen it where the adjudicator would say, sorry, you can't sell your house, or sorry, you can't move in because this tenant is going to be homeless, or their price range has now skyrocketed since they move in and they can't afford anywhere else?
Personally, no. I've never been in a situation where I've had that happen. I
usually get granted. It's just you got to go through the process.
Usually what will happen, what I have had happen is extensions in the timelines. So instead of saying, you're not getting possession of your house back, they'll just say, okay, well, we'll give them an extra month to look for a house. That seems to satisfy all parties. The landlords are a little screwed. The tenants are a little screwed. Everyone's a little unhappy, and the board gets to kind of find a middle ground. With that said, you have to go in prepared to make that argument, to say that, this is, especially now during COVID, this has gone on way too long. They've had so much opportunity. Often I will advise my clients to offer to assist them to locate properties, ask them what their budgets are, ask them, what they're looking for specifically in a house. What is it that they like the most about this property? See if you can find comparable properties and send them those comparable properties, because now when you get to the board level, you're saying, I tried to help them. I even gave them different, postings that they could have looked at. Did you even look at any of those? And then at that point, you've now put them into the hot seat where they're on defense, and now they have to establish that, well, they didn't really look, they didn't really take it seriously. And then from there, you should be able to whittle down that extension period and get it back into a reasonable realm for your client or for yourself.
So I know we got one more question. I'm going to try to skip into all of the other ones that we want to get to. So the N12s, when you are giving that 60 days notice, and if you have your tenant fighting that at the landlord and tenant board, where that 60 days now has passed, or it's going to pass, because it's now going to be heard at the board, some landlords go, I'm going to wait to give you that 1 month's rent until this case gets heard at the board. Would that result in a case being dismissed because the landlord didn't give the 1 month's rent before that 60-day notice date on the N12 notice?
Absolutely. You will have your case dismissed. You must pay the compensation. You must pay the compensation on or before the termination date. We see a lot of landlords right now who are out money on rent, and they're trying to offset. And that's a very dangerous game to play, because those adjudicators, it's entirely up to them whether or not they'll allow that. And if you have a strong advocate, you may be able to get through with it. You may not. It really is 100% up to the adjudicator. And that's where I say a little bit more consistency would be nice, but we don't have that. That's a very gray area right now. And taking that chance, it's 100% a chance. And I would never advise anyone to do that. I would say pay them the 1 month compensation as much as it burns.
Yep.
Get it done.
We had a tenant owing our landlord $43,000, and the landlord's trying to do the N12, and because she didn't give that 1 month's rent, even though the tenant owed her 43,000, it got dismissed. Okay, N13 notices. That seems to be the talk in the media. Rent evictions, but we've got old old buildings. They need renovations, and it's very difficult to work with mud and sanding and drilling and electrical and plumbing. Like, you do need to keep up on your supply, but the landlords are now taking advantage of that. But I see with the changes, maybe we won't be seeing a lot of N13s because you now have to pay them so much compensation. What are you seeing with the N13s?
I don't get very many N13s. I mean, I see this in the media and I'm like, who is dealing with all of these? Because I don't. I mean, over my career, I could count them on, all fingers and toes. I have not had that many in my career. And I just don't really think there is much of an issue as gets played up in the media. I think because it's a larger scale, especially right now with apartment buildings, like you mentioned, they're looking to upscale these apartments. The media is catching on. There's a lot of people impacted by this one specific building. But overall, I'd say it's not as common as what it's being played up to be.
Now, if you want to do an N13, obviously you're going to be telling them to leave. There's no time frame that the landlord's technically giving, but you do have to offer it back to the tenant at the same rate. Yeah. Now, what if they ask for renovations where that tenant landlord's trying to take like a 2-bedroom or a 2-bedroom unit or a 3-bedroom unit and make them into 2 1-bedrooms or changing the footprint of it. Would that be allowed, and how do you offer that back?
Well, you can't really, and that's part of where the sticky stuff comes in with N13s, and that's why I say just always talk to a representative before you do an N13, because those ones are just a little bit more complicated. You can't really offer that back once the unit no longer exists. How are you going to offer it back? So if you have the means to offer a comparable unit, then that's what you do. Otherwise, you pay the compensation because the unit isn't there, but that doesn't mean you're not going to get sued for it.
And now that we have to give compensation when they don't want the unit back, or if they do want the unit back, it seems like we still have to give them some type of compensation because you're utilizing the N13 notices. Mm-hmm. What kind of compensation are we looking at for the N13s?
I believe they want 3 months now.
And that's if they want it back or they don't want it back, like vote for both?
Don't quote me on that, Kayla. I'm not sure. I haven't done one
I know it.
Don't quote me on that. Yeah, we'll do a follow-up and let you know.
We'll do the follow, because that's the hairy one that when you read the instructions to it, it gets really, really dicey. And this is the concept. We need to make this more black and white. We've got so many people that need to represent themselves or want to represent themselves for financial reasons, and they should, but they make it so crazy and chaotic. It's not like other provinces where, both parties represent themselves.
I feel like we have changes as well. I feel like every year we have new changes coming through, and then everyone's in a tailspin trying to figure out what these new changes mean, and they're not, they're just a touch ambiguous, and now we're weeding through all of that ambiguity, and it takes a couple months for cases to start being heard. And yeah, I mean, by the time we figure out what everything looks like with the new N13, we're going to be dealing with new changes to the N13. So.
And you normally would say, like, we're kind of upset about all these changes, but some of these changes can be good. But I know when I first started advocating, it took me a long time just to even get some changes. So I'm actually okay with change, and I'm hoping to get more change, because now the board has stated that from the time of you filing, we're going to be starting to see 4 to 6 weeks by the end of the year. That's their goal, is to see these type of getting the hearing dates for that time frame, and that's successful. Again, we're trying to bring in that mediation before even a hearing. Let's get that mediation done and let that information being shared through mediation be heard at a hearing if it decides to go there later on down the road. But N4s, yay, N4s. It's always been the talk of it's the number one application at the Landlord and Tenant Board is an N4 application.
So many.
What is happening? What are the common mistakes there, and how do we avoid them to win the N4 case?
Your termination date is going to kill you if you don't have your termination date calculated correctly. And the biggest issue that I find with N4s is that everyone says, well, stick it in the mail. or I'll send it by courier, which I mean, I love courier because now I get a little stamp that I can punch in my numbers and it pulls it up and says it's been delivered. And I can print that off and put it in my file, and now I know for sure there's no argument that it was delivered to that address. So that's great. But you have to add extra days to your termination date if you're doing that, because if you don't add your extra 2 days for courier, your extra 5 days for mail, you're going to be in a position where your termination date from service is wrong, and now your application is gone, and you won't even know that until you get to the board. So it's definitely it's imperative to double check that termination date, and I always tell everyone add 2 days. Just add 2 days. It's not going to kill you to add those extra days. And with the N4, it's better safe than sorry. Everyone wants to get right on this 14-day, and they don't want to add any extra time. It's just add 2 days. Mm-hmm. Make sure that you have the termination correct. The other issue is that you're going to find the biggest issues with the N4 outside of the termination dates, the lease dates, the term dates, the start and the finish. You have a lot of leases that don't actually run the 1st to the 30th. And those are a big problem when it comes to N4s because people just instinctively want to say it's the 1st to the 30th, and often it's not. So make sure that you're correct on your dates, double check your lease, make sure that you're not the start date of the 5th or the 6th, and make sure that those dates are accurate in your terms.
So if your lease is on the 6th, that's when they moved into the place, but it's on the 1st of every month. As long as it says the 1st of every month, that is what you're going on.
Yeah, so a lot of leases will be, prorated, and those first 5 days are discounted, and it actually is for the 1st, but they took possession on the 6th. Those things are fine. Just double check your lease to make sure that that's the case, because if your start date is actually the 6th and rent is actually due on the 6th, but they've been paying early, then you could end up with an application dismissed because your start date is wrong.
Wouldn't it be an amazing service for landlord and tenant board to determine if there's errors on paperwork and allows the party to make those errors and not lose your spot? Like, they wait until you get there and like, sorry, start again.
What kills me, Kayla, is that the N4 specifically, it drives me batty. If you miscalculate the amount of rent due, and let's say you owe 2 months rent at $1,000 a month, and for some reason I'm just not thinking, and I put in that you owe $3,000 instead of $2,000, and then on the L1 everything's correct, and on the L1 update form everything's correct, we're going to get to the board and they're going to say, but your N4 was wrong, so your entire application is dismissed because you can't amend your notice. And I say, but they got 2 more notices. They got the L1 application. They got the L1 update form. You can't tell me that this ever-changing rent number and arrears number is the factor that's determining the dismissal of this application. It just doesn't make any sense because that originating document was wrong. In this case, a year and a half ago, it was wrong, and now, it's not the same number. We're not here for $3,000. We're here for $35,000, and now my entire application that drives me up the wall, Kayla.
I've heard of cases where if the landlord didn't put the actual payment amount, so here's the amount of owing, this is how much rent, here's how much rent is, this is when they paid, this is the total. So the total was perfect, but the landlord's payments of when the tenants had paid, because it's supposed to go back, whenever they make a payment, it goes back to the very the further back application of rent.
It can, yeah, that's up to the landlord if they want to apply that.
It's crazy. Absolutely crazy.
I always say do that because you get into a position where some people argue that you only have 1 year to go back. Others will say you have 7 years to go back, and others will say you can go back indefinitely for arrears. So I always say just apply it to the oldest arrears because, again, I don't like to get into extra arguments if I can avoid it. Let's just do everything to keep it as clean as possible. So always apply to the oldest arrears unless the tenant has specifically stated that it's for that month. So if on their check or on their e-transfer they've noted this is January 2021 rent, then that's the only month that can be applied to. Otherwise, apply it to the oldest arrears and get everything forward.
See,
if you're lucky enough to get money.
yeah, that's the part. Like they put like, here's your payments. I'm addressing it to the whole debt, but because they weren't giving the payments for that in particular month, the adjudicator threw it out. So it's again going back to your thing of the consistency. We need the consistency, especially when it comes down to N4. But hey, I don't fight my credit card bill when I don't pay it on time. You know, they slap you with a fee and you learn your lesson for the next time. N5s, you know, they seem to be, you know, they drive you. That's why I get my hair dyed. You know, it's you don't
That's
know.
why I should, Kayla. I should.
I got it done before COVID. Now it's like, come on, a second, you know, let's book in that hair appointment. The N5s, it's obviously interfering with the reasonable enjoyment. And we have so many tenants that, you know, if they struggle with their own personal life, they start making the life of the landlord's crap and the tenants. Like, what is tips can you give us, or common mistakes that are made even on the N5? Is it, you really got to make sure we narrow down the date and the time and the location and making sure that we're capturing the proof and not other tenants are capturing proof. Like, what mistakes are we doing that could be?
You nailed it. Those are the biggest issues. Not having the specific date and time, not having a list of what you saw specifically. The noise you heard, describe it. Was it a clicking sound? Was it yelling? Describe what you're hearing. I had one where the tenant next door is saying, they watched The Godfather on Tuesday night at 1 a.m. And I was like, did they tell you? Like, I heard every word. So write it in there. Let everyone know this is exactly what you're hearing, because the more detail you have of the N5, the stronger the N5. And if you can outline specifically, I saw the tenant do this, or I saw a guest of the tenant and I know it's a guest of the tenant for this reason, outline all of that, because again, the stronger it will be, stronger with more detail.
So we should get some security cameras going on in all of our properties and not pointing them at the windows or the doors, obviously.
And no audio.
So we got a lot of this stuff is happening because we're trying to keep the peace, right? And we're trying to keep the peace for the building. But again, the government and the landlord and tenant board, they work so much on the focus of the paperwork, but they're not listening to the parties in front of them. They need to see the whole picture. I know we have N4s and N5s and N8s, and all of these applications are being brought to the landlord and tenant board on one person. But what they do, they give multiple different hearing dates to handle it, or they might actually pool it, but they usually like to say, oh, you have an N4 as well, okay, we'll listen to that at a later date. It's like, you're wasting our time here. We paid for service.
Pre-COVID, patience paid off, because you could go in and you could say, I'd like to adjourn this to be heard with the other matter, and then we could pool them all together and we could hear them all. We'd send emails ahead of time, we'd request ahead of time by fax, make sure these are heard together. And that saved us a lot of time, and it sucked because we'd lose that first date, but it made sure that everything was together. And then the adjudicators got the full picture of what was happening with bad tenants. But now, like you said, no one wants to adjourn anything. I don't want to wait another 6 months to a year for a new hearing date. I mean, that's not the timeline realistically on an adjournment. It's more like a month or two. But still, in today's climate, we don't have another month or two. I have landlords literally losing their houses. Like, they don't have a month or two. So we can't afford to wait on that adjournment. We can't afford it. We have to go ahead and deal with it piece by piece by piece to try to get the eviction as soon as possible.
Now the stays, after you get an N4 or even an N5 or any judgment that comes from the board, we have our tenants applying for a stay, and that stay is automatically granted. And then the problem of it, that there's no record keeping of these stays. So some tenants are getting away with 3 stays unless the landlord's communicating with the board to say, hey, my tenant already got a stay. What are you doing here? These tenants are getting away with another stay. And we hope that they're addressing this with the new system that's coming from the Attorney General's office, something very similar to BC, a direct line communication. But now if we're giving all these N4s for our tenants, it's usually we can file an N8, and that's why I always tell my landlords, it's a business, it's not personal. I know your tenant's gonna pay you in a week or so, but give them that notice, because that is the notice that the landlord and tenant board wants to see in order for that N8 to be a valid N8, and then you can thrive with that N8 at the landlord and tenant board. But what mistakes do we make on that N8 that wouldn't allow us to put or it's really more of a, they just put a slap on the wrist and say, you now have to pay on time, every day, on time, and not a penny less. You know, is that how the N8s work?
Basically, day late, dollar short for the next 12 months. I mean, you really have to come in with more than just the N4s lined up. And the N4s lined up are a bare minimum. So you must come in. I would say don't go in with less than 5. If you have less than 5, you're probably going to run into issues even trying to get that 12-month order. If you can come in with 8 or more, you're in better shape to make the argument that nothing is going to work. But if you can come in with emails and communication to your tenant saying this is unacceptable, I'm issuing another, but like you said, you're peacekeeping, and as a property manager yourself, you understand that your job as a landlord and a property manager is to keep the tenants happy, keep the property maintained, also enforce your legal rights, also make sure you're not infringing on their legal rights, make sure the tenants all get along, make sure you get along with your tenants because you don't want to have a bad relation. It's a real juggling act that you're out there performing, and it's very difficult to have the documentation that you need to get that N8 while also maintaining a good relationship with your tenants, because they start to see the naggy landlord and the naggy property manager. So I like what you said, keep it business. This is business, business, business. And if you own a property and you have a tenant, they are not your friend and they will move on to another property at some point and you will be left with possibly a disaster. So make sure that you are protecting yourself and your investment.
Now I got a question for you. What's the difference between an N5 and an N7?
Really, one is just more serious. So the N7, it's more for the illegal acts. It's more for the serious danger. I had a landlord come to me who'd had units in his apartment building burned to the ground because a tenant left a stove on. That is something we issue an N7 for. So that's just far more serious. I would suggest really gauge, is it a safety issue or is it a nuisance issue? And if it's both, maybe do both forms. Make the termination date the same. Don't go by don't base it off of the minimum dates. Make the dates the same because it can be confusing. And if you can't make the dates the same for whatever reason, then send a letter explaining the dates, because that's another really big issue that we're seeing now. Applications that are perfect are being dismissed because there have been multiple applications filed and they all have different termination dates and the tenants are confused. So try to keep your termination dates consistent, and where that's not reasonable or possible, then just send a letter explaining this is how the N4 works. It's a voidable form and you can void it by paying. This is how this one works. It's non-voidable. So just make sure that you're trying to keep things simple.
Gotcha. Yeah. N7 and N6. I tell everybody that we kill a tree trying to evict someone or trying to sign them up for a rental unit because all the paperwork that we have to follow.
Yeah. I don't really find I use the N6 very often because everything's usually covered by the N7, N5. The N6 is kind of my big backup if I need to.
Is it more they lied on their rental income and there's a legal act, like they almost like they're covering each other, they're toppling over each other, doing the exact same thing. It's hard to know what form to fill out these days.
That's really it. And I mean, when in doubt, just read through the forms, read through what they're for, read through their bullet points, because they all tell you, they're very clear in their forms what they're for. To be honest, though, your N5, N7 is probably just going to cover you. And you have a better likelihood of getting an expedited with the N7. So
gotta love that form. so now that we have our N4s, number one application, because of COVID, I've always said it on all the different broadcasts that I do, is that you really need to sweeten it and show that, listen, there's a long time here. There's many options for our tenants to have served. They had the Canada Recovery benefit. They've had more money on child tax. We look at the concept that they have money, right? And they're not paying a single dollar. That's the concept that we're looking at, is they haven't paid a single dollar towards rent. And they're probably taking advantage of the rent strike movement. Even though a tenant is doing that, still send them the links to your different service providers to help them with rent relief, that bails them out for rent relief or relief from utilities for that matter. And showing the adjudicator that I'm even trying to guide them to different services to help them. And that's why the tenant did not do it. They failed to do it. And that's why I'm here today to ask for a standard order. And hopefully we're coming out on the second from this lockdown again.
Ask them what they think is reasonable to pay. Because I find that's a question that often doesn't get asked. Often it's just pay my rent or pay me this much or pay me this much. Ask the tenant what they think a reasonable amount is. They may surprise you. They may pay you more than you think. But if you can get something, it's better than nothing. And if they are intimidated by paying half the rent or even 3/4 of the rent or a third of the rent, ask them what they can do, because they know their budgets, they know what they can do. And if you can get something, then that too will work to your benefit when you get to the board to say, look, we even asked them what they could pay and then they didn't even pay that. So use it.
Agreement form, showing that we're here to work with you. And obviously if they don't give it back to you, and you've said that you've tried to give it to them so many times, but you can't give it to so many times because then it's now harassment that you're trying to get them to pay. So borderline on pushing that payment agreement down their throat, but hopefully that they can come up with that payment plan where they're carrying on with their normal payment, plus putting the delinquency rate inside of a payment plan that you can carry off on. And that's why every time that I'm talking to all of our landlords is making sure that they're aware of Landlord Credit Bureau, so that you can work in that payment agreement into Landlord Credit Bureau. So you're not affecting their credit and putting it to Equifax. You're able to take that payment plan that you've worked on and holding them to it by reporting that to Landlord Credit Bureau. And you also are going to reward your good tenants, the ones who have been paying rent throughout this crazy time, every single day, helping them build their credit and helping them become homeowners or landlords themselves.
And isn't it so great that you have that ability? Because this is such a huge payment every month, and people are paying so much in rent. It's the biggest payment anyone has in their rental life. Why not use that to their benefit? Why not have that building their credit for them? Like, it's phenomenal.
You know what tenants are doing? They would say that they would get a credit card. They finally got a credit card. And that what they do, they put a whole bunch of money on it and then just pay it off right away. And then more money on and then trying to pay it off. Right. It's like, that's little bits of it. That's a little bit. Like our tenants, my tenants themselves are seeing a score go up 40 points. Yeah. And that's unlike having good score, but and the people who have already had damage, trying to rebuild that, it's not as 40 points, but this is the game changer. This is bringing the fair and the balancedness into the rental industry that we've never had before. And if you see anything that's online where your people are, talking smack about it, it's because we do have our professional tenants who are trying to discourage landlords from utilizing this type of service. So don't always believe everything. If you ever have any questions, contact support at landlordcreditbureau.ca. Our members in Ontario Landlords Watch, we do have a discount for the monthly rate of OLW 15 for 15% off. So make sure that you guys are jumping over there and taking advantage and becoming a part of this landlord community that is now with Landlord Credit Bureau. And this is why I will harp and advocate as much as I can, just like I'm protecting the landlords and advocating at a provincial and municipal and regional level. I'm also making sure that I'm informing as many landlords as we possibly can. Guess what? We actually have an event that we're going to be bringing to everyone. It's going to be happening on October 7th. I'm having so much fun just planning that right now. I can't say too much, but there is going to be events. It is going to be virtual. So I know we got a lot of people that are inside going, I still don't want to go out and meet public yet. We're not too sure about the whole vaccine and whatnot. So it's going to be virtual, but it's going to be so worth it because it's going to be informative. It's going to be educational. And it's going to be very, very interactive. And it's going to have that same feel that you get when, if you already have been to one of our Ontario Landlords Watch conferences. So October 7th, 2021 is going to be our 4th Ontario Landlords Watch conference. And we have an amazing giveaway that's going to be coming out on June 1st when we actually give away $1,500 to one of our great tenants. I've got you landlords. You're going to email me your tenants. You're going to nominate them because they have been phenomenal to you and your property. We want to start rewarding these good tenants. We're not going to be putting, just like landlords, big or small, we don't want to be pegged as big landlords. Same thing with the tenants. Don't put them into one category as tenants. we want to make sure that we're rewarding our good tenants. And we're going to do that now starting June 1st, where we get to reward them. And don't worry, your good deed will come back, and you will be able to be rewarded on October 7th when we get a little prize for you guys. Leanne, thank you so much for tuning in and being here to give your expertise. And I know that we're going to be having so much more to have our members hear you, because this is only a touch. We're like, okay, we got 30 minutes. I'm like, let's go. How much can we do? It's like a timer, a game show. Ding.
It's always a pleasure talking to you, Kayla, and I look forward to October 7th. It's always a blast when you're planning an event. I look forward to it. It should be fun.
Oh, it's the stuff that I end up doing is it's my active thinking mind, and it's my passion to wanting to see justice to where justice is due. And before I get off here tonight, I want to make sure that I can get what's your website?
It's lawinoshawa.com.
Okay, so I'm going to get her link here so that everyone who's watching tonight is able to check in. And do you have a charge for a consultation, or you got like a free consultation?
No, we do a free consultation, especially now during COVID. We've gone fully virtual. Our office is running 100% virtual. So you won't do any in-person meetings. Everything is by Zoom, phone, and email. I just send us an email, request a meeting, and we're happy to schedule you in. You can also find us on Facebook.
We got you. This is awesome. Thanks so much. I can't thank you enough. I think the information that you were able to share with the members, and there's more. I know there's more. We got a lot of changes happening, guys. Fingers are crossed. The Attorney General is doing some stuff. We still have our stakeholders meeting with the Landlord and Tenant Board. We had a great conversation with one of the councillors in Ottawa today and advocating at that regional level. And we got to keep doing it. So making sure that you are indeed making sure that you're contacting your MPP, voicing your concerns with them. You need to make sure that you're filing your complaint with the Ontario Ombudsman if you're experiencing delays. And we built a huge community in the last 10 years. And this is what we're going to be celebrating now in October. And I can't wait to be able to share all this amazing information that is going to come out shortly. But if you have any questions while you're watching this video, put it into the chat, and Leanne and I will try to do our best to get to those questions, or give Leanne a call, or myself on Facebook, Kayla Andre. Thank you so much for tuning in. And until we do this again, happy renting. Take care.